Let me explain our decision today in the case of A.M. Zimbabwe against the Secretary of State for the Home Department. This appeal raises a question which arouses strong feelings. If a foreign citizen who is resident here in the UK has committed serious crimes, will his human rights save him from being deported back to his home country? The appellant is a citizen of Zimbabwe. He has lived in the UK for 20 years and has committed serious crimes. The worst was for possession of a firearm and ammunition, for which he was sentenced to 7 years. Now that he is out of prison, the Home Secretary proposes to enforce her order for him to be deported. The appellant is HIV positive. For several years, the NHS has been treating him with a particular drug which initially restored his CD4 blood count to a safe level and which has since stabilized his condition. In these long-running proceedings, the appellant has been appealing against the order for his deportation by reference to his human rights. At first, he based his appeal only on his right to respect for his personal and family life under Article 8 of the European Convention. But he no longer challenges the tribunal decision which dismissed his appeal under Article 8. Another of his human rights now takes center stage. It is his right not to be subjected to inhuman treatment under Article 3. When these proceedings began, the appellant's lawyers will have told him that he could not argue that his deportation would violate his right under Article 3. That was clear from decisions both in the House of Lords and in the court in Strasbourg some years ago in successive proceedings brought by a Ugandan woman called Ms. N against the UK government. Like the appellant, she was HIV positive, and again, as a result of treatment here, her condition was stable. The basis of both decisions was that, since she was not close to death here in the UK, the deportation of Ms. N to Uganda would not violate her right under Article 3, even though, because of the likely lack of adequate treatment for her in Uganda, she would probably die there within 2 years. Recently, however, in a case brought by Mr. Paposhvili, a citizen of Georgia, against Belgium, the court in Strasbourg has extended the ambit of Article 3 in relation to the deportation of people suffering serious ill health. It held that if, because of the absence of appropriate treatment in the country of their nationality, they would there suffer a substantial reduction in life expectancy, their deportation would violate Article 3. When, soon after the publication of that decision, the appellant's appeal was heard in the Court of Appeal, he asked to be allowed to switch the basis of his case from Article 8 to Article 3. But under our doctrine of precedent, the Court of Appeal remained bound by what the House of Lords had decided in Ms. N's case. So it had to rule that his proposed reliance on Article 3 remained a non-starter. But we in this court can depart from the decision of our predecessors in Ms. N's case. And in the light of the Paposhvili case, we today unanimously hold that we should do so. The Strasbourg court has indeed extended the ambit of Article 3 to an extent which, in the judgment, we have sought to analyze. But in Ms. N's case, the House of Lords itself expressed concern that its restrictive decision was arguably illogical in distinguishing between her imminent death in the UK and her early death abroad. This is not one of those highly exceptional situations in which we should decline to follow a decision of the Strasbourg court. We therefore allow the appeal and remit the appellant's proposed claim under Article 3 for consideration by an immigration tribunal, which will no doubt seek to conduct a full inquiry into, among other things, the adequacy of the medical treatment likely to be available to the appellant in Zimbabwe.